Hey folks, okay, so what I'm going to do here is I'm going to take you through a 4-part video presentation, and it's going to be composed of the first part, which is going to be about the original mortgage loan documentation, mainly just the promissory note and the security agreement, and then the second part is going to be about securitization, and then we're going to talk about MERS in the third part, and then we're going to talk about foreclosure procedure and the documentation related to foreclosure procedure in part 4. Okay, so for this first part, let's talk about the original closing documents that a homeowner signs. The two most important ones, the traditional contracts, are the promissory note, okay, promissory note, and a security agreement that secures the property to the repayment on the note, which is called a deed of trust here in California, and it's called a mortgage in many other states. So let me just talk just for a minute about the difference between a mortgage and a deed of trust. Okay, they're both security agreements. A mortgage is a two-party document where you have a mortgagor, who's the borrower, and a mortgagee, who's the lender, or if that loan is sold to somebody else, the new mortgagee is an assignee, okay? But mortgagor and mortgagee. Now, in deed of trust states, which are most of the western states, you have a 3-party contract where you have the trustor, who's the borrower, you have the beneficiary, who's the lender or the assignee, and then you have a third-party trustee who holds the title on behalf of either the lender, if they on behalf of the borrower if they repay the loan, or on behalf of the lender, the beneficiary, if they don't repay the loan. So 3-party arrangement, and that's called the deed of trust. Alright, so when I refer to a deed of trust, I typically also mean a mortgage, or when I refer to a mortgage, typically also refer to a deed of trust. Now, it's really common in these circles for people to just refer to the security agreement as a mortgage. Whether they mean mortgage or whether they mean deed of trust, it's pretty much interchangeable for the most part. Okay, so let's talk for a second about the security agreement, the deed of trust in this case, first. And okay, so what we have here is we have one of these, a very typical industry deed of trust from the 2000s, and it's a MERS related deed of trust, and so it's got a MERS MIN number on it, okay, MERS tracking number, and it has it lists the borrower, and it lists the name of the lender, and it lists MERS as a third party beneficiary. Now, it's a little bit tricky, and we'll talk a little bit about that in the MERS video, but they have MERS listed as the beneficiary in this. And this basically just says if you don't repay the loan, then this ties the property to that and will come repo the house. Okay, now the other document is the note, the promissory note. Okay, so this one here is 8.5 by 11. It's a copy. It's been shrunk, but the original promissory notes are 8.5 by 14 in size. All right. Now, this doesn't make any reference to MERS in it, and it lists the lender as, I believe in this case, Countrywide Home Loans, and it says what the terms are and the amount due and all that, and it may come with an adjustable rate rider, right, which refers to an amortization schedule and all of that. But what's important about these notes is that these are negotiable instruments. So just like a check is a negotiable instrument, these are governed under the Uniform Commercial Code, which has been adopted in, I believe, all the states, and maybe slightly changed, but for the most part, it is the Uniform Commercial Code is pretty much the same in all states for the most part. And it's Article 3 that governs it. Article 4 governs checks. Article 3 governs these kinds of negotiable instruments. And they are transferred or assigned by physical possession and endorsement, just like a check. So it has a pay to in the text there in the front, and it can be endorsed on the back page, kind of like a check. And this is a blown up version of it here, but there's an endorsement. This one you're looking at there is called a blank endorsement. It says pay to the order of, and then there's just a blank line there. Okay, that's like when I write you a check and I leave the payee line blank. That means whoever is going to cash the check just fills in their name and cashes it. What matters is that it's signed, that it's endorsed. Same thing here. Okay, so you can also endorse a check or a promissory note with what's called a special endorsement. And that means that the person who is going to be the holder, the bearer, the person who's going to cash it or have rights to it, is going to be listed with their name specifically listed in there. So it's a pay to the order of J.P. Morgan or whatever. This one here is paid to the order of blank. Very common that promissory notes get transferred that way. And what that means is if it's endorsed in blank, that means it becomes what they call bearer paper. And whoever's holding it has the right to make a claim to it. All right? And so that's the promissory note. Now, the promissory note was never typically recorded in the county recorder's office. Okay, it's transferred in the secondary mortgage market, and it's done so privately. And what is recorded in the county recorder's office is the corresponding security agreement, the deed of trust or mortgage. All right. Now, when a mortgage loan gets assigned in the secondary mortgage market, then with the assignment of the note, there typically should be, in good faith, there should be an assignment of the security agreement too. So what you would see in the county recorder's office is you'd see the original deed of trust, and then you'd see an assignment of deed of trust to whoever bought the note. Okay, we're not seeing that with these securitized mortgages, so we're going to go into that more later. But that's the basics of the original loan documentation that really that we really are dealing with here. The original note and the security agreement. And now let's go into securitization. Okay, so now let's talk about securitization. All right, so securitization is the process of pooling many thousands of mortgage loans into a trust which issues mortgage-backed securities to investors. The investors that hold those securities have rights to payments that are coming from homeowners. Okay, so a securitization platform generally has 4 parties, okay? And so that is the originator, the sponsor, the depositor, and then the trust fund, which has a trustee. All right? Now, we're going to be going over a particular securitized trust here. It is the Goldman Sachs GSR Mortgage Loan Trust 2006-OA1. All right? So this is a private securitization. You also have government-sponsored securitizations, which are Fannie Mae, Freddie Mac sponsored securitizations mainly. And but this is a private one, so this is Goldman Sachs, and similar ones will be like Citibank and Lehman Brothers and Bear Stearns, and they will all have similar documentation. All right. Now, the laws which pertain to these trusts are the trust indentures, okay, the pooling and servicing agreement and other related trust indentures, the laws of the state of New York, which is where these trusts are formed, the IRS Code, Title 26, Section 860, and the Uniform Commercial Code. So these particular types of securitized trusts are called REMIC trusts, Real Estate Mortgage Investment Conduits. Okay, so I'm going to look at their prospectus now, which is sort of like a synopsis of the operation for investors to look at. And again, like I just said, these are the four parties. You have the originator, you have the sponsor, you have the depositor, and then you have the trustee of the trust. Okay? So when a mortgage loan gets securitized, it needs to be transferred through all of those parties. All right? And because mortgage notes are negotiable instruments, they need to be passed by possession. So they physically have to be transferred, and then they have to be endorsed. Now, you could just endorse it. You could endorse a mortgage note in blank and pass it on, but there are trust indentures, pooling and servicing agreements, which in many cases state that there needs to be more than one endorsement, and that is to satisfy New York trust law. So let's take a look. Let's take a look at some relevant sections of the pooling and servicing agreement for this trust, and these are very typical. So I'm going to read to you from section 201, where it talks about the transfer of the mortgage loans into the trust, so you can see what's required for a proper securitization. Article 2, conveyance of depositor's interest in trust fund, representations and warranties. Section 201, conveyance of mortgage loans. The depositor, concurrently with the execution and delivery hereof, hereby sells, transfers, assigns, sets over, and otherwise conveys to the trustee, for the benefit of the certificate holders, without recourse, all the right, title, and interest of the depositor in and to the trust fund. In connection with the transfer and assignment of each mortgage loan, the depositor has delivered or caused to be delivered to the custodian on behalf of the trustee for the benefit of the certificate holders the following documents or instruments with respect to each applicable mortgage loan so assigned. The original mortgage note endorsed without recourse in blank by the last endorsee, including all intervening endorsements showing a complete chain of endorsement from the originator to the last endorsee. And then they go on to list the other documentation that needs to go into to a custodian, actually, to the trustee's custodian for the benefit of the trust fund. All right, so what they're saying there is in order for this securitization to happen, they want the mortgage note to be transferred with intervening endorsements. So we saw that the parties to the securitization are Countrywide Home Loans as originator, Goldman Sachs Mortgage Company as sponsor, GS Mortgage Securities Corp as depositor, and then Deutsche Bank National Trust Company as the trustee. All right? So what you should see for a proper securitization when you look at the promissory note is you should see on the front of the promissory note, you'll see that the lender is named as Countrywide Home Loans. And then on the back of the promissory note, this is a blown up copy of it here, you should see an endorsement from Countrywide Home Loans. Okay, good so far. But then you should also see an endorsement from Goldman Sachs Mortgage Company, the sponsor, and you should see an endorsement from the depositor, GS Mortgage Securities Corp. Now, in this case, you don't see you don't see those endorsements. Okay, so in this case, and this is very common, extremely common, the this note does not comport with the requirements in the trust indentures. Okay, and so New York trust law says that an indenture trustee has to follow the trust indentures to the letter. Otherwise, if there's any ambiguity there, then they don't take title to the property which is being transferred. So that's why the trust indenture says that it's going to be very clear and unambiguous as to who had the notes and who therefore has the right to them. Okay, so this also has to be done by a certain date. All right, and so that is also referred to in the pooling and servicing agreement, and that's the closing date and the cutoff date. And those are two related dates with different functions, but they're close. In this case, the closing date is August 24th, 2006, and the cutoff date is August 1st, 2006. So for this securitization to be proper, right, to be lawful, and for the trustee, Goldman Sachs, or excuse me, Deutsche Bank National Trust Company, to have title, okay, then the promissory note needed to be transferred with all three of those endorsements before the date in August of 2006. Okay, so when we go into some of the other videos where we look at some of the foreclosure documentation, we're going to look at some of that and see if there's any breaks there. We're going to see if there's any documentation which does not comport with the pooling and servicing agreement. Okay, so we did just now see that the note was not endorsed properly. All right, so you're going to have some cases now, some court cases where attorneys for the homeowners are going to be arguing that if the trust indenture is breached, then the trustee did not take title and therefore doesn't have standing to foreclose. And I think that's correct. All right, but that's securitization. And in regards to the MERS system, in the next video we're going to talk about MERS, and we're going to talk about how MERS interfaces with this and the problems that we have with the MERS system. Okay, so see you on the next one. Okay, so let's talk about the MERS system now. So MERS is short for Mortgage Electronic Registration Systems, and it was designed in the banking industry in the 90s as a way to track and trace transfer of interest and servicing rights from party to party in the secondary mortgage market. And it was there to help speed and aid in the securitization process. Okay, so the way MERS works is that MERS shows up as the beneficiary or the mortgagee on a deed of trust or mortgage. Okay, and so then what happens is everybody in the banking industry becomes a MERS member, and anyone that's dealing with transfers of servicing rights mostly can sign into the MERS system, and they can have their employees come on as MERS certifying officers. And so this is an agency system. Now, one of the unfortunate things is that there was no enforcement if parties failed to record interest in the computer system. And so what we see very typically is we will analyze the situation and we'll know that a mortgage note was transferred to 3-4 parties in a securitization, but yet when we look at the MERS milestone reports, which are not public documents, you have to get through court discovery, you'll find that there are no milestones or one milestone or missing milestones, and that's just because there was no enforcement. They were sloppy. And so even if the MERS system, even if we could get all of the milestones made public, it would not, in many cases, give us a clear understanding of who the parties are. So, like we talked about in the securitization video, there are usually about 4 parties involved in securitization. And so what normally you would see under the law as it's been for hundreds of years, every time a note was assigned, you'd see a corresponding assignment of the security agreement, the mortgage or deed of trust. But what we're seeing now, because they wanted that to be private, is we're not seeing those assignments in the county recorder's office. And so let's say a loan is securitized in 2006, and we go into the recorder's office in 2010, that record is not true and correct, okay? Because the assignments are being done internally, if at all. Now, in the case of a foreclosure, they need the foreclosure to be initiated by the beneficiary or mortgagee, who is the note holder, and so they do assignments out of the MERS system to whoever the note holder is. And I'm going to get into that in the next video as to what those assignments look like and all that. But what it's important to know is that MERS doesn't actually have any interest in the notes, any beneficial interest in the deeds of trust, okay? And so it can only act as an agent on behalf of the note holder. So when you see a MERS assignment, understand that it has to be taking place on behalf of the note holder. Now, it's unfortunate that they don't list, when MERS signs something, they don't list who they're acting on behalf of, okay? And so you have to know more about where that mortgage loan went in order to figure out who they're acting on behalf of. But even when you know that, it doesn't make any sense. Okay, but so really quickly here, I just want to read to you a little bit of testimony from MERS CEO R.K. Arnold, where he admits that MERS doesn't have interest in the notes or any beneficial interest. Okay, so the homeowner attorney asks R.K. Arnold, and let me just tell you where this comes out of. This comes out of a deposition. This comes out of R.K. Arnold, MERS CEO deposition, November 10th, 2010. You can find that online. He's asked, is it true that your company has nothing to do with origination of underwriting any mortgage loan? Answer, yes. And is it true that your company never extended credit to any consumer? Answer, yes. And is it true that your company does not purchase or sell mortgage loans? True. And it's true that your company is never an investor in a mortgage loan? True. Your system does not actually create any beneficial interest in a mortgage loan, does it? True. And it does not transfer any beneficial interest in a mortgage loan, does it? True. In fact, what your system does is tracks the paper documents which are the subjects of these agreements and endorsements and things that we've been discussing this morning, right? Yes. And it's the members that utilize the system to track it. Okay. Let's also read to you from a California bankruptcy case. In Ricky Walker, debtor, where the judge says, since MERS did not own the underlying note, it could not transfer the beneficial interest of the deed of trust to another. Any attempt to transfer the beneficial interest of a deed of trust without ownership of the underlying note is void under California law. Okay, and so there's courts everywhere that are saying this, especially the bankruptcy courts. But so we know that MERS doesn't have any interest in the notes. And so they have to act on behalf of the note owner. So first, whoever the note owner is, they have to have the note at the time MERS commits any actions on their behalf. So any assignments of deed of trust or assignments of mortgage, they have to be done at the time that the assignor has the note to assign it to the assignee. And they have to be MERS members. Okay. Now, we're going to go over an assignment in the next video. And what we're going to see is that that assignment uses language which doesn't apply to MERS because they don't have any interest. Doesn't apply to the original lender because they had sold their interest into securitization years before. Okay? And doesn't apply to the securitization platform's depositor because they're not a MERS member. And so we're going to go into that, and we're going to see why these assignments, why these MERS assignments have a lot of language in them which is untrue, okay? And so which would invalidate those assignments. All right, so I think in this short video, I can't get into a whole lot more about MERS, because to do so would require probably a good 30-40 minutes to really go into all of it. But that's all for now, and then let's go to the next video about the types of assignments that you're going to see in the county recorder's offices. Okay, so now let's go over some of the documentation which we'll see filed in the county recorder's offices after foreclosure proceedings are initiated. Now, I'm going to be mainly referring to procedure here in California or non-judicial foreclosure states, but you're going to see the same kind of documentation show up in judicial states also. Okay, now, because the industry thought that the MERS system was going to work properly, they never recorded any assignments of the mortgages or deeds of trust in the county recorder's offices when the notes were transferred into the securitization platform. So we won't see any transfers from the originator to the sponsor, from the sponsor to the depositor, from the depositor to the trust. We're not going to see any of that, right? But what needs to happen in most of these states is that the party who is entitled to initiate foreclosure proceedings is the beneficiary or mortgagee of record. And what's happened is, because all these notes have been securitized, the original lender on the deed of trust or mortgage is not the current owner of the note. They're not the current beneficiary or mortgagee of record. So what has to happen is they need to assign the interest out of MERS and into the securitized trust. Now, if they had had it their way, MERS would initiate, or foreclosure proceedings would be initiated on behalf of MERS, and because they were the original mortgagee or beneficiary, they would also be the mortgagee or beneficiary of record who has the right to foreclose, and there would be no need for an assignment. But because the courts started rejecting them so heavily over the last couple of years, they have changed their policy, and so now they assign interest out of the MERS system and to the beneficiary, or to the true, or what hopefully is the true beneficiary or mortgagee. Okay, now there's two kinds of assignments that you're going to see. You're going to see assignments to the trustee of a securitized trust, or you're going to see assignments to their servicer. Now, in the case of assignments to the servicer is never the note holder or note owner if the mortgage was securitized, because it's the trustee of the trust that has the title. So anytime you see an assignment to a servicer like BAC Home Loan Servicing LP or GMAC Mortgage or any of these servicers, that's invalid on its face, because they're not the note holder, they're not the note owner, and they can get into all sorts of language with the word holder and all this. But if the securitization was done properly, it's the trust that owns the note. Okay, so the assignment should always be to the trust, right? If we were going to be dealing with the facts, with the truth of the matter. But what we see a number of other problems. Even when we do see assignments to the securitized trust, there's a number of other reasons why the assignment is invalid. So let me read some of the language here. So this one here says, for value received, the undersigned hereby grants, assigns, and transfers to Deutsche Bank National Trust Company as trustee for GSR 2006 OA1 all beneficial interest under that certain deed of trust, and it lists the deed of trust, describing the land therein, it lists it, together with the note or notes therein described or referred to, the money due and to become due, etc. So what they're saying here is that for value received, they transfer all beneficial interest in the deed of trust together with the note. And they do it according to the execution date on March 29th, 2010. All right? And it's executed by Flor Valerio, Assistant Secretary of MERS, and it's notarized on April 8th of 2010. Okay, so let's go over some of that. First of all, we went over in the MERS video some testimony from R.K. Arnold, and we also looked at that Walker case, but I have a lot of more information on this. We know that MERS does not handle the notes, they don't make any loans, they don't have any interest in the notes, any of this. Okay, so it says for value received. They receive no value, so that's untrue. It says they transfer all beneficial interest, but they have no beneficial interest, so that's untrue. It says they transfer the note, but they never had the note, have any interest in the note. They never transfer or touch the note, and so that's untrue. Okay? So then we also have this problem where if this loan is actually been properly securitized and Deutsche Bank National Trust Company, as trustee for this securitized trust, actually has the right to the note, well then they would have had to follow their pooling and servicing agreement, their trust indenture. And that says that the notes will be transferred by August of 2006, right? The closing date. And so this is executed on March 29th of 2010, almost 4 years later. Okay, so this is outside of the trust indenture. So this can't be legal, right? It's also notarized, a week later, and that's because they made a mistake and they started initiating foreclosure proceedings before they had become the beneficiary of record. And so when they figured that out and they started started to foreclose, they said, "Oh well, we need to backdate this assignment." Okay. Now, what about Flor Valerio, Assistant Secretary of MERS? Well, the way MERS works is that the company she works for, probably in this case Recon Trust or Land Safe Title, the company she works for will send in a list of employees that they want to be MERS certifying officers. And then MERS kicks them back a corporate resolution and Flor Valerio's name should be on that. But according to the way it should work, the parties need to be officers of the member corporation. So if we go and look at the Secretary of State's information and we find out who the officers of Recon Trust or Land Safe Title are, we should see Flor Valerio on there. But if we don't, we know that she doesn't have the ability to bind the corporation, and so that's invalid. We also know that these parties should be attesting to what they have knowledge of, but we know that that's not happening. We know everything about the whole robo-signer scandal, right? So that's who Flor Valerio is. And sometimes we have situations where the notary's signature doesn't match their oath and certificate, which is filed in the county recorder's office. And so in this case it does, but it's very common that the notary's signature doesn't match either. So these are a variety of issues. We've discussed why the language is untrue and incorrect, why it is voidable, and now what happens if this assignment is invalid? Well, if the assignment is invalid, then everything that's filed subsequent to this, like a notice of default, a notice of trustee sale, or a substitution of trustee, those are all invalid because they're all based on the fact that this party, Deutsche Bank National Trust Company, is the beneficiary. But if they're not, then all that's invalid. Now, really quickly before this video ends, in California we have Civil Code 2936, which says that wherever the note goes, the security goes. So what we really need to look at is the note. And in this particular case, which there's a ongoing litigation about, we've looked at the note. And I showed that to you earlier. Try to find that here. And the note is not endorsed. I have to pull it out. The note is not endorsed according to the pooling and servicing agreement. So the note never made it into the trust. So Deutsche Bank is not a beneficiary. They are not a beneficiary of record, and they don't have the right to foreclose.